She wrote a book about grief to explain a loss she was accused of causing. And then, she was handed the ultimate punishment. On May 13th, 2026, Kouri Richins sat inside a Utah courtroom in complete silence as a judge delivered the words that would define the rest of her life. Life in prison, without the possibility of parole. For the family of her late husband, Kouri Richins, it felt like closure, like a long, painful chapter had finally ended. The curtain had closed, and the woman accused of destroying their family was finally behind bars. But in true crime, a sentence is never really the end of the story. Because behind prison walls, something unexpected was already beginning. Kouri Richins was not accepting defeat. She was preparing for a legal war, a fight not for sympathy, but for reversal. And her defense team believes they may have found something powerful enough to challenge everything the jury decided. Not emotion, not public opinion, but legal error. And if they are right, this case may not be as finished as it seems. The moment Kouri Richins entered the Utah State Correctional Facility, the clock started ticking. By law, her legal team had a strict deadline to act. A motion for a new trial had to be filed by June 10th. But almost immediately, a problem emerged. Kouri was placed under a mandatory 30-day lockdown. No phone calls, no meetings, no real access to her legal team. Just isolation. And for her attorneys, that changed everything. They rushed to the court asking for more time, a new deadline, June 30th. They argued it was simple fairness. How can a defendant prepare a legal challenge without access to her own lawyers? But prosecutors pushed back hard. They said the defense had time, plenty of time, and accused them of doing something else entirely, delaying closure for the victim's family. What looked like a procedural argument was actually something bigger, a preview of a much deeper strategy, because behind the scenes, Kouri Richins' legal team was changing. Old trial attorneys were stepping back and being replaced by specialized appellate lawyers, lawyers who don't focus on storytelling, they focus on technical collapse, on finding cracks in the system that can overturn even the strongest conviction. And according to court filings and objections already preserved during trial, those cracks are already being targeted. Now, before we go deeper, there's something important to understand. Her official appeal brief is still being finalized. But based on the record already built in court, 5 major arguments are emerging as the foundation of her fight. Each one attacks the case from a different angle. Number 1, the fentanyl ghost. The prosecution's case never showed a direct moment of administration. No video, no eyewitness, no physical evidence of Kouri allegedly putting fentanyl into Eric's drink. Instead, the case was built on circumstantial connections, and her defense is expected to argue something very specific, that the jury filled in the gaps with assumption, not proof beyond reasonable doubt. Number 2, the contested witness. A key witness claimed she sold drugs connected to the case, but the defense argues this testimony is unstable. They point to memory inconsistencies and claims of pressure during questioning. If the appellate court agrees this testimony was unreliable, a major pillar of the prosecution's narrative weakens. Number 3, the jury location. Before trial, the defense asked to move the case out of Summit County. They argued media coverage had already shaped public opinion. The judge denied that request. Now on appeal, that decision is being reframed as a constitutional issue, a question of whether Kouri ever had a truly neutral jury. Number 4, the jury instructions. Just before deliberations, the judge adjusted how the jury should evaluate evidence. The defense argues those instructions limited how jurors could interpret uncertainty. In other words, they may have been guided toward one conclusion. And number 5, sentencing timing. The defense attempted to delay sentencing. They said they needed more time to present mitigation evidence, but the court proceeded anyway. And now they argue that rush may have influenced a life without parole outcome. Together, These arguments form the backbone of an appeal now officially in motion. The Utah Court of Appeals has accepted the case. But no hearing date has been set, and appellate courts move slowly, sometimes very slowly. But even while the legal system waits, Kouri does not get to pause her reality, because another court date is already scheduled. A mandatory restitution hearing on July 31st, where financial consequences tied to the case will be addressed. Insurance, assets, allegations of fraud tied to Eric's estate. A second courtroom battle running parallel to the appeal. So where does that leave everything? Kouri Richins is no longer just the woman who wrote about grief, no longer just the center of a murder trial. She is now an inmate, launching a legal fight that could redefine the outcome of one of the most talked about cases in recent memory. And the question now is no longer just what the jury decided, but whether that decision will survive the appeals process. Because if even one of these arguments holds, everything could be reopened. A new trial, a new jury, a new version of the story. But if they fail, then the sentence that was handed down in that Utah courtroom will become permanent.